This is civil procedure for the bar exam essay statements of law. Diversity subject matter jurisdiction. The issue is whether a federal court has jurisdiction over the action. Federal jurisdiction courts have limited subject matter jurisdiction and may only hear actions that involve federal questions or diversity of citizenship where the amount in controversy exceeds $75,000. Shared citizenship between any plaintiff and any defendant destroys diversity jurisdiction. A corporation is a citizen of both the state of its incorporation and of the state where it has its principal place of business. A permanent resident is a citizen of the state where she is domiciled. Domestic relations. The issue is whether the federal court has jurisdiction over the state breach of contract dispute based on domestic relations issues. Generally, federal courts do not hear domestic relations cases. State law and courts control matters of divorce decree, child custody, and support. Federal courts may hear matters of contract tort or other issues deriving from domestic relations issues. Permissive joinder. The issue is whether permissive joinder of claims against all defendants is proper. Permissive joinder allows plaintiffs to join together as multiple plaintiffs or to join multiple defendants in the same action. Multiple persons may be joined together as plaintiffs or defendants in one action if 1. The claim arises out of the same transaction or occurrence. 2. Any question of law or fact is common to all plaintiffs. Permissive joinder allows for judicial economy. Insufficient service of process. The issue is whether the defendant may make a motion to dismiss for insufficiency of service of process. When the defendant has already moved to dismiss for failure to state a claim upon which relief can be granted. When a motion to dismiss pursuant to 12b is initially made, a party may join with that motion all other motions permitted by Rule 12 that are then available to the party. If a party makes a Rule 12b motion and fails to join certain other available defenses or objections, the party may not later raise those objections and defenses. In particular, a party that makes a Rule 12b motion but omits from that motion a defense or insufficiency of service of process is deemed to have waived that defense. Cross-claim. The issue is whether the defendant's cross-claim against plaintiff, whether defendant's cross-claim against plaintiff arises out of the same events of plaintiff's claim against the defendant. Rule 13G of the Federal Rules of Civil Procedure provides that a defendant's answer may state as a cross-claim against a co-defendant any claim that arises out of the transaction or occurrence that is the subject matter of the original action between the plaintiff and the defendant. To determine whether two different claims arise out of the same transaction or occurrence for the purposes of Rule 13, federal courts look at 1. Whether the issues of fact and law in the plaintiff's claim and the defendant's cross-claim are essentially the same. 2. Whether the same evidence would support or refute the plaintiff's claim and the defendant's cross-claim. 3. Whether there is a logical relationship between the plaintiff's claim and the defendant's cross-claim. And 4. Whether res judicata would bar subsequent suit in the cross-claim. Supplemental jurisdiction on a cross-claim. A federal court would not have subject matter over the same claim over defendant's claim against plaintiff if that claim were filed as an independent action. However, if the original claim and the cross-claim are sufficiently closely related to form part of the same case of controversy under Article 3 of the United States Constitution, the supplemental jurisdiction statute authorizes the federal court to take jurisdiction over the cross-claim. cross-claim for less than $75,000 between citizens of the same state. The issue is whether a federal court would have independent subject matter jurisdiction over a state law cross-claim for less than $75,000 between two defendants who are citizens of the same state. The federal question statute grants federal jurisdiction states' courts original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. A claim arises under federal law creates the cause of action. Diversity jurisdiction is available when the plaintiffs and defendants are residents of different states, but requires at least $75,000 in controversy. Because the claim is less than $75,000, and because there is no diversity because the citizens are both from the same state, the federal jurisdiction does not have independent subject matter jurisdiction over the claim. The issue is whether the defendant's claim against plaintiff is so related to plaintiff's claim against the defendant, of which the court has original jurisdiction, that the claims form part of the same case or controversy under Article 3 of the Constitution. Supplemental jurisdiction statute permits federal courts that have original jurisdiction of a civil action to assert supplemental jurisdiction over all other claims that are so related to the claims in action within such original jurisdiction that they form part of the same case or controversy under Article 3 of the United States Constitution. Claims form part of the same case or controversy under Article 3 if they derive from a common nucleus of operative fact. Cross-claims that satisfy Rule 13G's transaction or occurrence test presumptively satisfy the common nucleus of operative fact test and are within the court's supplemental jurisdiction. Appeal. The issue is whether defendant can immediately appeal the district court's order granting plaintiff motion for judgment on the pleadings with respect to the counterclaim. In federal court, a judge's order is only appealable if it is the final judgment in the case. A final judgment is one that adjudicates all claims, effectively settling the matter between the parties. However, Federal Rules of Civil Procedure 54B permits a court to apply a final judgment order to an individual claim that does not fully resolve the case when the court finds that there is no just reason for delaying an appeal. In such instances, the final judgment claim may be appealed to a higher court while the remainder of the claims in the case is still pending. Removal. The issue is whether the federal court in State A has removal jurisdiction over the case. A case filed in state court is removable by a defendant to federal court if the case falls within the original jurisdiction of the federal court. Federal courts have diversity jurisdiction if there is complete diversity of citizenship between the plaintiff and the defendant, and the amount in controversy is in excess of $75,000. In actions where federal jurisdiction is based on diversity, a defendant cannot remove the case to federal court if the case was filed in a state court in the defendant's home state. Change of venue. The issue is whether the change of venue motion seeking the transfer of the case to federal court in State B should be granted. A motion for change of venue is governed by 28 U.S.C., provides in its entirety for the convenience of parties and witnesses. In the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought. Transfer pursuant to convenience and interest of justice standard of 1404 is discretionary, but transfer under 1404 may be made only in a district in which the action might originally have been brought. Venue is proper in a district where any defendant resides if all defendants reside in the same state. In addition, venue is proper in State B under 1391A2, which permits venue in any judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. Supreme Court has ruled that a reasonable forum selection clause is a relevant factor favoring 1404 change of venue motion, even if the forum selection clause is unenforceable under the applicable state law. Judges have a good deal of discretion under 1404, but normally a judge would allow a plaintiff's original venue choice to prevail, where the facts are closely divided on the issues of convenience and interest of justice. Amendment of answers after close of discovery. The issue is whether a defendant can amend its answers after the close of discovery to include an affirmative defense. Under Rule 15 of the Federal Rules of Civil Procedure, a court must give a party leave to amend its pleadings where justice requires. The court, in determining whether leave should be given, must consider 1. The length and reason for delay, and 2. Prejudice to the opposing party. Typically, a court will deny leave to amend when there is undue delay, bad faith, futility, or undue prejudice. Motion for summary judgment. The issue is whether the court should grant defendant's motion for summary judgment. Pursuant to Rule 56 of the Federal Rules of Civil Procedure, summary judgment should be granted when there is no genuine issue as to any material fact, and the movement is entitled to summary judgment as a matter of law. An issue is genuine if a juror could reasonably conclude the fact in favor of the non-moving party. A fact is material if it is necessary to support one of the elements of a claim. When determining a motion for summary judgment, the court will view facts in the light most favorable to the non-moving party. In order to prevail on its motion for summary judgment, defendant must prove that there is no genuine issue as to any material fact in relation to the affirmative defense. Preclusion. The issue is whether the claim can be precluded by res judicata. Once a case has reached final judgment, then that case and related claims and issues have been decided or settled permanently and are not eligible for relitigation. The doctrine of res judicata, or claim preclusion, prevents relitigation of a claim or all claims. 1. Between the same parties and those who are privy to them. 2. Arising out of the same transaction or occurrence. And 3. That were determined on the merits by a court with proper jurisdiction. Collateral estoppel. The issue is whether a person can relitigate an issue when the jury has made a decision. Collateral estoppel, also known as issue preclusion, prevents relitigation of issues that were fully and fairly litigated and were necessarily decided in a proceeding that reached final judgment on the merits. Collateral estoppel may not be used against someone who was not a party to the previous action. Collateral estoppel may be used offensively by someone who was not a party to the first action against someone who was a party in the earlier suit. However, courts are reluctant to permit offensive use of issue preclusion and will base their determination on the following. 1. Whether the plaintiff in the second suit could have easily joined in the first action. 2. Whether there are procedural opportunities available to the defendant in the second suit that were unavailable in the earlier action. And 3. Whether the defendant had incentive to litigate the issue in the first action. Intervention as a matter of right. The issue is whether party can join the action as a matter of right. Intervention allows a non-party to assert a right or interest in an ongoing action. A person is entitled to intervene in an action as a matter of right when he 1. Claims an interest relating to the property or transaction that is subject to the action. 2. Is so situated that the disposition of the action may as a practical matter impair or impede his ability to protect that interest. And 3. The existing parties do not adequately represent the applicant's interest. TRO. The issue is whether the court will issue a temporary restraining order. A temporary restraining order is a form of provision relief used in emergency situations. A TRO generally lasts only a few days, long enough for the party to seek a preliminary injunction, and no longer than 14 days. A court may issue a TRO without written or oral notice to the adverse party. To obtain a TRO without notice, the party must submit an affidavit containing specific facts that demonstrate a risk of immediate and irreparable injury. A party seeking a TRO must establish the same elements as a preliminary injunction. 1. Substantial likelihood of success on the merits. 2. Irreparable harm. 3. Balance of hardship. And 4. Public interest. Preliminary injunction. A preliminary injunction is available to maintain the status quo and prevent irreparable damage or wasting of assets during litigation. A party seeking a preliminary injunction must first establish 1. Irreparable harm will be suffered unless the remedy sought is issued. 2. The harm to the plaintiff if the preliminary injunction is denied is greater than the harm to the defendant if the remedy is granted. 3. The provisional remedy, if granted, will not be adverse to the public interest. And 4. A substantial likelihood of success on the merits. A preliminary injunction will last until a decision on the merits. Service of process. Rule 4 of the Federal Rules of Civil Procedure details how a plaintiff may serve process upon a corporation. If the defendant is a corporation, a plaintiff can properly serve process by delivering a copy of the summons and complaint to 1. An officer, 2. A managing agent or general agent, or 3. Any other agent authorized by law to receive service of process. In addition, the rule allows a plaintiff to serve process upon a corporation by following state law for serving a summons. In a diversity suit, the federal court will apply its own law to procedural matters. Subject matter jurisdiction. Federal courts have original jurisdiction over 1. All civil actions arising under the Constitution, laws, and treaties of the United States, and 2. Matters involving litigants who are citizens of different states if the amount in controversy is more than $75,000. For diversity purposes, corporations have dual citizenship. Corporation is a citizen of the state where it is incorporated and the state where it has its principal place of business, the nerve center. The principal place of business is where the corporation maintains its headquarters unless there is evidence to the contrary. Improper joinder. According to Rule 14a, a defendant may proceed against a non-party who may be liable for all or part of the plaintiff's claim against the defendant. This is the only circumstance enumerated under the rule where a defendant could bring a non-party into an action instituted by the plaintiff. Personal jurisdiction, long-arm statute. A state court may exercise personal jurisdiction over an out-of-state defendant if authorized by the state's long-arm statute. Jurisdiction under a long-arm statute must satisfy constitutional requirements. The defendant must have such minimum contacts with the foreign state so as not to offend traditional notions of fair play and substantial justice. For jurisdiction to be constitutional under a minimum contacts analysis, the defendant must have established a minimum contact with the foreign state. The claim against the defendant must arise from that contact, and the exercise of jurisdiction must not offend traditional notions of fair play and substantial justice. Where there are only a few contacts with the state, the contacts must directly relate to the cause of action asserted. This is called specific jurisdiction. A non-resident defendant is subject to specific jurisdiction when the defendant purposely availed itself of the privilege of conducting activities within the state, such an exercise of jurisdiction by the forum state would be foreseeable. In determining fairness, courts consider 1. The burden on the defendant, 2. The interests of the forum state, 3. The plaintiff's interest in obtaining relief, 4. The interstate judicial system's interest in efficiency, and 5. The shared policy interests of the states. Supplemental jurisdiction. Supplemental jurisdiction allows a federal court to hear claims over which it would not ordinarily have jurisdiction. Those claims can piggyback on a claim that does fall within a federal subject matter jurisdiction. Supplemental jurisdiction is only available over a claim if that claim arises out of the same transaction or occurrence as a claim over which the court would have subject matter jurisdiction. Claims arise out of the same transaction or occurrence if they arise out of a common nucleus of operative fact. Courts may decline to exercise supplemental jurisdiction where 1. The claim includes novel or complex issues of state law, 2. State law claims predominate over the federal claim, or 3. The district court's dismissal of all other claims over which it had the district court's dismissal of all the claims over which it had original jurisdiction. Ooh, that's a tough one. Motion to dismiss waiver. Motion to dismiss based on insufficient service of process must be made in the defending party's first response to the court. If the defending party makes a motion to dismiss and insufficient service of process is not included, that defense is generally waived. A motion to dismiss may be amended prior to hearing when the adverse party is not prejudiced and the amendment will not cause delay. Although not expressly provided for in the FRCP, a preliminary motion may be amended to include a defense or objection that was inadvertently omitted. Sufficiency of service. If the defendant is a natural person, process can be served by personally delivering the process to the defendant, wherever they may be, serving their registered agent, or leaving process at her last and usual place of abode with a person of suitable age and discretion who resides there. Choice of law. Federal courts exercising diversity jurisdiction apply the choice of law rules of the state in which it sits. Motions for sanctions. Under Rule 11, an attorney who presents a pleading to the court certifies that, to the best of her knowledge, information, and belief, 1. The document is not being presented for any improper purpose. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. 3. The factual contentions have evidentiary support or will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4. The denials of factual contentions are either warranted on the evidence or are reasonably based on belief or a lack of information. If the court finds that any of the above representations are untrue, it has discretion to impose sanctions on the party or the party's attorney. Sanctions are ordered after notice to the offending party and an opportunity to be heard. Under the safe harbor rule, a party may not file a motion for sanctions without first serving the motion upon the opposing party and providing the opposing party with 21 days to withdraw or correct the offending pleading. Appropriate sanctions. The court has significant discretion in imposing sanctions. The nature of the sanction must be limited to what would be sufficient to deter repetition of the conduct or comparable conduct by others. An order imposing sanctions must describe the sanctioned conduct and explain the basis for the sanctions. If a party fails to make an admission, and if the requesting party later proves the document to be genuine or the matter true, the requesting party may move that the party who failed to admit pay the reasonable expenses, including attorney's fees, incurred in making that proof. Appropriate party to be sanctioned. A court may impose sanctions on any attorney, law firm, or party that violated Rule 11 or is responsible for the violation. Erie Doctrine. Under the Erie Doctrine, a state law will apply if it is a law that deals with the substantive rights of state citizens. However, federal courts will use federal, not state, procedural rules. Under Rule 23, a class action may be maintained by a party if the court finds that there is a numerosity, commonality, typicality, and adequacy of representation. Federal rules for class certification apply to all class actions in federal courts, including those based on diversity. State laws on class certification are superseded. Standing. The representative party in a class action lawsuit must have standing to bring their claim. Federal jurisdiction is limited to cases and controversies. In order to establish standing, a person must show 1. Injury in fact, 2. Causation, that the injury was caused by the challenged action, and 3. Redressability. The plaintiff must show a direct and personal injury, actual or imminent, caused by the action that he is challenging. Where the plaintiff has not suffered any concrete personal injury or harm, he does not have standing. Permissive joinder. Permissive joinder allows multiple plaintiffs to join together in a single action and allows multiple defendants to be sued in a single action. Multiple defendants may be joined in one action if 1. The joined defendants face liability that arise out of the same transaction or occurrence, and 2. Any question of law or fact is common to the joined parties. In determining whether a claim arises out of the same transaction or occurrence, courts will often ask whether the claims are logically related. If there is a logical relationship between the claims, and it would serve the judicial economy to hear the related claims together, the test is met. Impleader. An indemnity claim is a claim that shifts all the defendant's liability to a new party. After a defendant to an action has served her answer, that defendant may proceed against a non-party who may be liable for all or part of the plaintiff's claim against the defendant. Impleader thus allows a defending party to shift all or part of the liability owed to the plaintiff to a new party who is or may be liable for it. A defendant may file a third-party complaint any time within 14 days of filing her answer. After that, third-party complaints may be filed only with the leave of court. Compulsory counterclaims. A compulsory counterclaim is one that arises out of the same transaction or occurrence as the original claim in the lawsuit. A failure to raise a compulsory counterclaim waives the right to assert the claim in any future action. The doctrine of claim preclusion prevents relitigation of a claim, 1. Between the same parties and those who are in privity with them, 2. Arising out of the same transaction or occurrence underlying the prior suit, and 3. That was determined on the merits by a court with proper subject matter and personal jurisdiction. Issue preclusion. Issue preclusion prevents relitigation of issues that are fully and fairly litigated in a proceeding that reached a final judgment on the merits. For litigation of a particular factual issue to be precluded, 4 elements must be met. 1. The issue must have been litigated and determined in the prior suit. 2. The issue must have been essential to the judgment. 3. The prior suit must have ended in a valid judgment on the merits. And 4. The party against whom preclusion is asserted must have had a full and fair opportunity and incentive to litigate the issue in the first suit. In most states and in federal court, issue preclusion may be used offensively by one who is not a party to the first action against one who is a party to the earlier suit. In a minority of states, a non-party who would not be bound by a finding in the first suit contrary to the non-party's interests cannot use a finding from the first suit that is favorable to the non-party. A federal diversity court will apply the claim and issue preclusion rules of the state court in the state in which the federal diversity court sits. I think we're done. We're close. Rules Enabling Act. If there's a federal rule promulgated under the Rules Enabling Act dealing with an issue, that rule is applied unless it abridges, enlarges, or modifies a substantive right. Federal Rules of Civil Procedure are statutes drafted by judicial branch and approved by Congress. Federal courts use federal, not state, procedural rules. Under the Federal Rules of Civil Procedure, pleadings must contain a short and plain statement of the claim showing that the pleader is entitled to relief. There are no special pleading rules for certain things under the Federal Rules of Civil Procedure. Motion to dismiss if a party cannot be joined. When joinder is required but is not feasible, the court must determine in equitable grounds whether to allow the suit to proceed or instead to dismiss it. This determination is largely a discretionary one. The interests to be considered include the plaintiff's interest in access to its chosen forum, the defendant's interest in avoiding conflicting obligations or being subject to duplicative litigation, the interests of the absent party, and the public interest in meaningful judicial resolution of disputes. This has been Federal Rules of Civil Procedure, Statements of Law for the Bar Exam Essay section.